All right. Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live this afternoon will have the opportunity to ask questions and interact with our speaker. If you have a question, please type it into the comment section below and we will be sure to address it. Yes, you heard that right. We are live today, so please interact, send questions, and just let us know how you're doing today if you feel like it. Episodes are released each week following the live broadcast. So if you know somebody who wasn't able to be here with us today, or if you didn't have a chance to show up, please feel free to check that out next week. Today, we have Brent Crumpton with us out of Birmingham, Alabama, and he's going to talk to us about why we lose. This is a great topic, and I honestly don't think that we can hear enough about it. Even if we think we know why we lose, even if we talk to the jury after a loss and they told us why they think we lost, most of the time that is not the full picture. Now, Brent practices personal injury law in in Birmingham. Didn't I just say he's in Birmingham? In addition to being KTI faculty, teaching advanced openings and black letter law. As always, we will put his contact information in the description below so that you can contact him directly with any questions that you have about this topic or anything else Edge. Brent, tell us about why we lose and how Edge can help turn our L's into W's.
Sure, Jenna. Thank you so much for having me. I mean, one of the big issues that we have is that as we learn the edge and we go through the system and begin to have these successes, which all of us do, at some point in time, we're going to have something occur that's not exactly what we were hoping. So, for example, while we're not losing like we used to, in fact, most of the folks that I deal with nowadays are getting verdict after verdict. From time to time, we do have one that goes off the rails. And oftentimes we have a verdict that when we get it back, it turns out it's not nearly what we were hoping for. Mm-hmm. And so one of the things that we learn when we're doing the edge is that we learn all about systems and systems failures. And the edge really is by far the most complete compartmentalized system for conducting a trial. And for those of you who've had the opportunity to go through the colleges and take the courses and then actually implement it in your practice, you know that we have a step for each and everything that we want to do. And most of the time we have a checklist, and then that each one of these compartments will interface with another compartment together to bring us with a complete program, a complete system, right? So one of the things that we have to look at is that when something goes wrong, we have to take that ability that we have learned to conduct a systems failure analysis, that ability to conduct a root cause analysis, if you will, and turn it back on ourselves. And so one of the things that I've been fortunate enough to do is not only in my practice, but I've had the opportunity to work with other lawyers, younger lawyers, who are coming along. And so I've had the ability to get to do basically autopsies, if you will, on cases that have not turned out the way that folks would hope. And what I'd like to do today is I've got a little bit of a PowerPoint presentation, but I want to walk through sort of each of the major system failures that I'm seeing, and I think a lot of folks are experiencing, and then just talk a little bit about how we can address each one of those systems failures to ensure it doesn't happen again. Because ultimately, as we're conducting our root cause analysis, at the end, what we want is to be able to go back and take the action that's necessary to ensure that it never happens again. So the criticism that we may level against the defendant from time to time, that they haven't taken action to prevent it, we need to turn around and level that against ourselves to make sure the next time that we try a case, we get the result that we're looking for. Let me share my screen here, if you will, with everybody. And hang on one second, just to make sure I've got the right one up. And from the beginning here. All right, so we all know and we're very familiar with the edge itself. And what our motto here is that we're giving trial lawyers the system they deserve to win, protect our community, safety, and to deter wrongdoers by holding them accountable. All right, so, and I've underlined here is that system and the importance of the system itself. And so one of the things is, what is a system? Well, we all know, based upon our own interactions with systems, that there are lots of different ways of defining it, but you see here I put up basically the word flex definition, and you can see how broad it is, from techniques to approaches to sets of procedures and guidelines. And so again, sort of brings us back to what is it that the Edge provides for all of us. And again, it provides us with a complete system. And so when we have something that goes wrong, okay, when we ask for a 7-figure verdict and we get a 5-figure verdict, or we have done everything right and then all of a sudden it's a so-called admitted liability case, right? And then they come back with a defense verdict. Well, how in the world could they come back with a defense verdict if it's admitted liability? We've seen all of those things take place, and all of those things are teachable moments for us to stop and to unpack them. As painful as they may be, we need to sit down and take them apart. So for those of you who do medical malpractice, you know that there is an M&M committee and that there is peer review and that they go back and autopsy very carefully what happened. And so kind of what I do in each of one of the cases that I'm involved in or I'm asked to participate in when we don't get the result we want, or even when an individual part of the system does not go off as planned, doesn't perform the way that we wanted it to, we're going to go back and do our own sort of M&M conference to see exactly what it was that caused this problem to take place. So one of the things that I want to point everybody to that I think is incredibly important is Don wrote a blog back in April of 2019, and it's called Systems Failure Analysis, the Ultimate. Okay. And so for all of those of you out there who have access to this, go back and read this, because what you're going to see me talking about today really comes from this. And in particular, in this blog, Don created a chart, basically a complete overview chart, and it's called Why We Lose. And it is a chart that outlines each and every compartmentalized aspect of the Edge, how they interact with one another, and the various ways in which these systems can go wrong. Okay, and what I'm going to do, instead of putting it up on the screen for all of you to see, I'm going to talk about it, but I'm not going to show it to you. I'm going to encourage you to go pull that blog and to read it yourself. Now, I can tell you how important that is, that picture of why we lose. Okay, I've had that blown up and I put it in every associate's office. Okay, it's on a giant poster board, and everybody has it in their office and they look at it every single day. And the reason is because it is a wonderful visual overview of our entire system. And it's an overview that allows you, when you're going through it, to see exactly how you win. And I think it should equally be titled How Do You Win, as much as how we lose. But anytime something goes wrong, I can guarantee you can go pinpoint somewhere on that system exactly where something went off the rails, right? And it breaks down to really two things. Is one, either you don't yet know that system for how to conduct that particular part of the trial, which is easily fixable. You just simply go to a college or you go to a seminar and you sit down and you learn it, and you'll find that there is a specific checklist, a specific methodology. You'll get the opportunity to role play it, to learn it, to bring it into your toolbox, if you will, so that you can do it from there on. And then there's the other part, which really breaks down to self-discipline, is that you know better and you do it and you don't do it anyway, right? And so unfortunately, that often comes from a function of time, okay? And for those of you who've been doing this long enough, you know that to do it right is a time-consuming process, and sometimes we lack the self-discipline and we cut a corner here or there, and inevitably you're going to find out that when something goes wrong, it's usually a result of that corner that got cut. So, you know, that's, again, another issue that we all have to deal with, but it's one that we all pay a price for whenever we ignore it. One of the things that I stress with the folks, and I stress it with myself when things go wrong, is that developing success from failure, discouragement and failures are two of the major stepping stones to success. So I've been fortunate enough that since I have been doing this, I have not had a loss in the sense of not had a defense verdict, but I have had verdicts where I have gotten the result that's far less than what I was hoping to get. And I know that I step into that when that happens, as, you know, maybe a weekend of drinking, and then after that I'm finished, and then let's go back and figure out brutal honesty, what went wrong, what happened, and we're going to take the whole thing apart and see exactly what it was that took place. And that's what I encourage all of you to do, because you know you're going to learn so much more from your failures than you are from your successes. And these are things that will be etched into your memory. And hopefully, if you work with others, that you will take those lessons and then share them with other folks, whether people in your office or on your listserv or whatever. Y'all will go out and sort of talk about exactly what went wrong. And I like to see that from time to time when people have the courage to step up and talk about their losses. If you try cases, you lose cases, and therefore, the best way to get past it is to talk with others about it and hope that you can prevent that from happening again in the future. So today, what I want to do is talk a little bit about what it is that you're going to do to lose the cases. So where's the first place that something is going to go wrong, and probably the most profound place where something is going to go wrong? And that's at intake, right? So what is happening here is that you are misevaluating the kind of case that you have, right? So when you're misevaluating the kind of case that you have, that means that you are more than likely violating the case selection criteria. Okay. And for those of you who know the old reptile book, it's now The Edge, but the old reptile book, chapter 15 was the shortest, but I think the most important chapter in the entire book. And that was chapter 15 was case selection. And I put up here on the screen just some excerpts from that. But all of you know this, and all of you who have been through the colleges, who started in the rules course and worked your way through, understands that the three components of the case selection criteria that are listed down at the bottom, okay, the defendant's conduct, how it could impact random victims, community survival issues, why should the community care about the outcome of the case, and systems failures on an edge level, as I'll call it now, what happened that can happen again, are essential to the intake of the case. They're essential to the structure of the entire case all the way through. They're essential to your closing, to every part of that case. But if you make that misstep at the beginning of the case, okay, that is not something that's easily recoverable from. If you end up having an event case, okay, as you go through the colleges and learn, there are ways that you can sort of patch that, work around that, find ways to create, I'll call it a synthetic systems failure when it's not a perfect systems failure. There are ways around it, but you have to be honest with yourself and understand that you may very well have an event case and not a systems failure case. So that's step number one. And I find that from time to time that lawyers will go try a case, and at the end of the case, it doesn't turn out the way that they wanted, usually in terms of the amount of money. And what they find is that when they're talking to the jurors, that the jurors really weren't tapped in to the case selection criteria. They were really looking at it as a one-off event case, and they treated the case as such. So again, that's the very first part of the case that you have to look at. The next part of the case that you have to be, that sort of goes hand in glove at the very beginning of it as well, is the idea of focus groups, okay? And so for those of you who've been doing this for a while, you know that focus grouping the cases starts at the very beginning, right? And so, there are lots of different focus groups, right? And as you go through this process and go to the different colleges and learn that, I think at last count, at least when I went to advanced focus groups, there were 28 kinds of focus groups, right? And so you need to understand that there are very specific tools, if you will, focus groups that are designed to extract very specific information that you need as you go through the case. But at the very beginning of the case, obviously you need to be doing a focus group, a narrative focus group, and seeing exactly what kind of emotional reaction that you're getting from the focus group. In other words, are you about to sign up a case and spend the time and the money on the case when your focus groups are telling you that they don't really care, okay? That it doesn't move the needle for them, they're not all that concerned about it. And so one of those things for everybody who is doing focus groups is to understand that at some point in time, to be really good at this, you just need to check your ego and let go of the need that your opinion doesn't make any difference any longer. You need to learn how to do these focus groups correctly and then trust the outcome of these focus groups so that you can make sure that you've got a case where on a scale of 0 to 10, these focus groups are thinking, this is a 9, this is a 10, this is something that needs to be dealt with, and that, the world isn't right until this gets taken care of. Those are the cases that you're looking for. If you're taking cases where you're getting a 3 or a 4 and people are yawning and they're not all that concerned, then at least have the expectation that once you spend the time and the money and then you take it to trial, that you're probably going to get a 3 or a 4 type verdict. You're not going to be getting that other kind of verdict. At least know what you're getting into and be honest with yourself at the beginning of it. All right. The next area that we want to talk a little bit about is once you get through the case selection criteria and once you begin the process of putting these things together, another area where I find that folks sort of go off the reservation, if you will, is when they begin to sort of put together the visuals for their cases. All right. And so one of the things that y'all all know about is the mechanism of injury, the mechanism of the event, the rules. Okay. When you start to go through and put those together, there are focus groups that are designed specifically to help you put those things together to ensure that they're done correctly. But what I see a lot of times is that the visuals are put together at the last moment, that there isn't a real clear MOE. There's not a real clear MOI. Most folks have gotten the rules down really well and know to use a rules board, know to put those things together visually. But just remember, if you don't have a clear MOE and an MOI, if it's confusing and if the jury can't understand what happened, then you're going to lose. Just because a confused juror or confused jury is a defense jury, right? And so part of making sure that you go through that process is please don't wait till the last minute. And again, that's a time issue, but try to go through as best you can and get those MOEs and MOIs done early, get them focus grouped early, make sure that they're clear, because those things that are done at the last minute that you think I'll do it the week before trial and put something together, if you get them in, oftentimes they do not. And I've had as a referring attorney, we've had some situations where we put together images for a brain injury case. And we spent a lot of time working on them, and man, we thought they were great. Well, the problem was it was we who was thinking and not the focus group who was thinking. So we thought, oh, this is perfect. And we gave it to a focus group, and they came up with all sorts of scenarios that we never thought of that had nothing to do with what we were trying to demonstrate, none of which were good for us. And it took us 3 or 4 different times of going through and revising and redoing everything until we got to a point where we were communicating with them clearly. So just, again, understand that you don't have a good MOI or a good MOE until the focus groups tell you that you've got a good MOI. Okay. The next thing that we see from time to time that's a problem is we see your opportunity to get information early in written discovery. Okay. Take advantage of that, especially requests for admissions. But that's going to, again, and we're going to talk about hit lists in a minute, that again is going to require you to have sat down and thought these things through and to have focus grouped these things as well. To have the focus group assist you in telling you what it is they want to know and why they want to know it. And the earlier you can get that information and put it together, and the earlier you can get it out to the other side, especially in an RFA, before they're organized, before they have a theory of the case or understand your theory of the case, that gives you a huge advantage. And so, we have found out that sending out, and I think in several of the brain injury cases, we sent out 150, 200 requests for admissions we had 7 or 8 different defendants on very discrete issues, locking them in probably a year before they were ever going to sit down for a deposition. And it made a huge difference. But again, that's going to be a function of the amount of time that you have and how far ahead are you. One of the things that, for all of you who do this already, you're going to laugh because I'm about to say this, but for those of you who are just getting involved in it, you do all the work on the front end, okay? You don't have any of this stuff as you're racing toward trial. You're not panicking those last 3 weeks before trial trying to put everything together. You've done all the heavy lifting back when you had the time, when you had the energy, when you had the focus, and you had planned it all before to make sure that it was all done. But again, that goes back to the self-discipline issue. And if you can do that, and then what you have to then do is to learn to develop the patience to wait for the defendants to catch up, right? Because it'll be a year or two before the light bulb goes on in terms of exactly where you are and what you've already done. But again, that's just something that relates to getting out ahead early and staying out ahead the entire time. The next thing we're going to talk about is the depositions, okay? And there's two different things I want to talk about here that I think are important. And the first one, for all of you who know this, is your own client's deposition, right? And so one of the things that we see, and I see that in particular in a state like Alabama where I still have contrib, right? And I've got pure contributory negligence in this state, so 1% on my client equals 0. So this used to be one of the most excruciatingly unnerving things in my practice was my client sitting for deposition. It was something that I really hated, not only because I had no control over it, but because I didn't have a system in order to ensure that I had my client where they needed to be. And so obviously the witness preparation system that the Edge has is an absolute game changer. For all of those of you who use it and have been using it, you really understand that you took what you used to feel was your weakest link, and now you've turned it into the tip of the spear in terms of you understand your client has an amazing power and ability to be able to speak their major truths, to not feel guilty about what they're saying or what they're doing, and to clearly articulate on their own behalf that they were doing their job and that none of this is their fault. And so what happens is that folks who don't use the witness preparation system correctly or don't use it at all, unfortunately, I'm still seeing where the focus goes back onto their client becomes the issue, and then obviously negative attribution kicks in, things take over. You have problems where you otherwise wouldn't have problems. So that's something that obviously, is important. The second thing is the defendant's deposition. And I think that just recently, KTI has come out with hit list training, right? And I think that hit list training, and I know when people talk about things from KTI, everybody says game changer. And honestly, in each area in which we're talking about, each one of these courses and classes is a game changer. But the hit list training, to me, is something that it allows you to end the case, if you will, before the defense ever understands what happened to them. And so, what's happening in these cases in which you've gone and developed the hit list, you actually know what you need, how to ask it. You've been through it, you've role played it, you've focus grouped it, you know exactly what you're going to get and whether you got it or not. Once you go through and you actually execute that part of it, for all intents and purposes, the case is over. At least in most of the cases that I have, it's over because all I've got to do is go back into the courtroom and reproduce that exact same cross-examination again, and then we're in good shape from that point on. But when it comes to doing the hit list, one of the things that I see is I'll have associates who will send me a hit list like 48 hours before a deposition. And I'm like, no, reschedule. We're not doing that. Is to take the time again to make sure that you've put it together. You've got what you need. You've cross-referenced it with your jury instructions, with your focus groups. You put those things together. But just as importantly is that you've taken the time to sit down and actually role play it. Okay. And for those of you who've started doing role play or have always done role play, you understand that from the human brain standpoint, that role play, that visualization is every bit as real as the real thing is. And that all you're doing is giving yourself additional experiences and then making sure that whichever way the rabbit runs, that you already have thought that through, have which of the 4 ways or ways that could possibly answer the question. You've run down each of those rabbit trails, and that basically you're sort of just shooting fish in a barrel as opposed to trying to react or think in real time in a pressure situation. And so, again, if you can go through and do that and learn how to do that, and I know that's a fairly new course, but for those of you who have not had the chance to take it yet, get out there and take that and start implementing that as part of your process. It makes an absolute huge difference. And then one other thing too is making sure that you're always keeping in mind, okay, the order in which you're going to take the depositions, right? And that's an important thing. And as you go through, you'll learn all about making sure you've got the right order, and then you're going to learn techniques about echoing, techniques about visually echoing, about verbally echoing, and then making sure that you make your life easier for yourself as you're going through your discovery, because you've thought things through and are just simply taking one deposition after the other and just recreating those same great hits that you got in the first deposition as you go through. So now let's sort of switch a little bit now and talk about some of the things that I see a little bit at trial. And these are cases that I try myself, as well as cases where I go watch other folks try cases or help other folks pick a jury, is going through. And the first part, obviously, is where things go horribly wrong is in voir dire, right? And so one of the things that y'all all know about voir dire is that, we have, fortunately for all of us, that basically we have the Keenan pie, right? So for those of you who had struggled with voir dire, didn't have a system, didn't have an understanding of a system, well, now you, for those of you who have been using it and understand it, you've got something that goes through in the correct order, okay, each and every one of these potential issues that you need to deal with. And what I see is that, one, a lot of folks who do this don't have enough practice, okay? So one of the things that y'all know to do is that each of your focus groups is make sure you take some time in every focus group and do a little bit of practice as it relates to your voir dire. The second thing I see is that sometimes there has not been a lot of thought given to your which way do you lean questions, okay? And so, again, you've got focus groups. They're going to tell you what's important. They're going to tell you how they want you to deal with certain issues. And you've got to take the time to put those which way do you lean questions together in a way that ensures that you can get that issue where you need to. So in other words, if you need to swift boat the issue, that you can make sure that you've got it where you want it, and that you know what those critical issues are that have to be dealt with. Because, between voir dire and opening statement, at the end of those, you should be way ahead, if not having already won your case. But if you slip up on some of these things, or some of these things are not inserted where they need to be inserted, then you can end up having a number of problems. And obviously, if you get to a point where your voir dire allows for rats to board the ship, that is something that later on that you will probably not survive, at least in terms of one rat can sink a ship, two rats together can certainly bring your verdict down. If not, I'm in a unanimous verdict state. So if I've got two folks to get together and decide to hold out on something, that's pretty much can be the end of us. So making sure that you've put everything together to ensure that you are keeping that from happening is an essential part of what you're doing. But I think that, special issues come up in cases. And recently, while I tried different kinds of cases, recently I thought, well, let me try something that I normally don't try. And it was a low visible property damage case with either admitted liability, if you will, or certainly conceded, if not admitted liability, against an individual defendant, okay? Those are some of the hardest cases for those of you who try those cases. Those are by far some of the hardest cases to try, because the point of view will shift on you during the case. And by that, I mean, we were certainly able to get everybody to fully understand the rules violation, the systems failures, all of the issues we talked about earlier that relate to case selection criteria. But you have to be very cognizant of the fact that when you're asking a jury to return 6 or 7 figures against an individual, they will oftentimes begin to put themselves in the shoes of the individual for purposes of whether or not they could ever themselves pay that kind of money, okay? So then you better have gone back, and your focus groups will tell you that. They'll let you know that's a lot of money. That put me in the poorhouse if I had to pay something that big. And insert what you need to insert in your voir dire to ensure that you are giving at least a fair chance from them that they're judging the conduct and they're not judging the individual. And you will go through and read, Don has wonderful blogs that talk about different times in which he's faced that issue. So you can go back and look at the anthology, and you will find verbatim ways of dealing with those particular issues to ensure that that is not a problem. Because if you think you're just going to skip it and you're not going to address it, if you're just going to go ahead and ostrich and bury your head in the sand about that particular issue, you're going to find that you're going to get a verdict, but then they're going to give you a verdict that's in the realm of what they think they can pay. And unfortunately, that ain't going to be a lot. So those little things to make sure that you're paying attention are, again, one of the things I see when I'm seeing somebody get a result that's not what they want. They skip that part, or they miss that part, or they didn't pay attention to that part at all. And then after voir dire, okay, and let me talk a little bit about swift boating here. And these are some of the main issues that kind of come up when we talk about swift boating. Okay, in these kinds of things, pre-existing injuries, you guys all know pre-existing injuries are something that you need to embrace, not something that you need to run from, right? So you need to make sure that you're conducting a proper voir dire on that. Wrecks that occur, and I'm talking right here just sort of in the context of a motor vehicle situation, wrecks that occur before and wrecks that occur after, right? So a lot of times what you have is people will think to themselves, or you'll have jurors have a very strong belief that if a wreck occurs after the wreck that you're involved in, that wreck then cuts off, okay, your ability to be able to recover damages past that point, right? And so you need to make sure that from a medical evidence standpoint, you deal with that issue. But also, if it turns out, for example, that you can't get past that they're all saying, okay, well, they were in this wreck and then they had a second wreck and it was much worse than the first wreck, you can't get past that, then what you need to do is sort of redevelop your damages model for the period of time from when that wreck happened, the first wreck, to when the second wreck happened, and then refocus and recalibrate how you're going to ask for damages on that. And again, go back and look at the blogs, go back and look at the anthology, and and go back and look at the videos, for example, on, what's 45 days worth of pain and suffering, right? So as long as you're aware of what you're facing and what's coming at you, and you've looked at it thoughtfully and you've got the assistance of a focus group, I'm of the opinion that, again, if you follow the case selection criteria, that you're going to find a way to be able to get a verdict that's a just verdict. But if you ignore those things and just plow ahead, it's not going to turn out well for you. And so that's one of the things is that damages model, you need to know how to adjust your damages model based upon how it is that these focus groups are coming back and telling you how they're going to look at these things. Gaps in treatment, okay. Again, you just have to talk about gaps in treatment during voir dire. I mean, we're all busy. We all have other things to do. This person has a job. There are always wonderful, plausible explanations that you can tap into that the jurors will go along with, so long as you've recognized them, and then so long as you work through that portion of your voir dire with a focus group to make sure that you can bring that around. And if you can't bring it around, then you can limit the person or try to exclude the person from the jury. Limited duration of treatment, those are obviously issues that you're going to have to deal with. And so one of the things that you're going to see, and I think all of you see this all the time, is once you go through and thread the needle on these things, and you know that you've threaded the needle because your focus groups have told you that, and the profiles of the answers that you're getting are matching the focus group profiles that you're getting. Once you thread that needle, the defendant is completely unaware of what you've done for the most part, because they're going to stay on script and pound away, even if the venire has clearly told you that doesn't bother me. The defense will turn around and continue to pound on it. And when that happens, you know that things are going your way, that they're completely oblivious to what is happening in front of them. So really, all these 800-pound gorillas are issues that you have. You guys will learn the techniques of swift boating if you haven't already. Go through and prepare yourself for them and be ready. But to me, if you do not deal with this is where you will lose. So you drop the ball here, and then you give a wonderful opening. It doesn't matter, because the thought process of the jurors is not going to match. It's not going to plug into what your opening is going to be. So as wonderful and great as it was, and as well put together, the audience is not receptive for it. And at that point in time, it's pretty much game over for the most part. The next thing that I see in terms of after that is making sure you got the rats off the jury. So that to me is something that that's why you need to practice and do focus groups and go through so many focus groups and practice voir dires, is because when you get to spot them, when you see them from their body language, when you hear them say those horrible words, well, I need more information. Those are the things that allow you to see what those rats look like. And I can tell you that very early on, when I started doing this, I tried a case and did not have the ability to actually identify one, and the other one didn't have the ability to get them off. And they took what was an 8-figure verdict and turned it into a very, very low 7-figure verdict. Okay. And it was because the two of them got together and were able to convince everyone else that the case really wasn't worth 15, 17 million. It was really worth more like $1.5 million. So that kind of stuff, and we found that out because the judge, we showed us, I guess maybe she was just being sadistic, showed us all of everybody's notes just at the end after it was over, kind of saying, well, you had almost all of them. But that was just simply because those two folks were able to come in and do what they were able to do. And they were able to push everybody around on a Friday afternoon. And that was the way that happened. So be aware of that, and also be prepared to arm all of your good jurors with the information that you have to ensure that if you suspect you've got a rat on board, okay, if you've got that person, it's hard to tell sometimes, but if you do that, make sure that you have given everybody else what they need to push back to give you what you're asking for. Okay. The next place we sort of go to where I see things go wrong is on experts. Okay. An expert is not going to win your case for you, but an expert pretty much could lose your case for you. So when you're going through and lining up for your expert retention, okay, you guys all know you're looking for an expert who is going to be a teacher. Okay. You know that the expert is somebody who, you should have, and if you go through the colleges and take the colleges, you will have a checklist for preparing your expert. Okay. So your expert will go hand in glove with the way that you want to try the case. And that's obviously early on. You need to make sure that the expert and the way that they conduct themselves and their opinions align with the EDGE methodology in terms of presenting a case. So about systems failures and their ability to support your statistics and all of those things that are necessary elements for you to be able to put it on the EDGE way, make sure that your expert is able to do that, or that you get a different expert. Okay. And then make sure your expert checks their ego at the door. I mean, you've got a lot of experts who are, parachuting in and out of places that are doing really well, all this kind of stuff. But when you get that feeling, right? And obviously early on, if you have any concerns at all about your expert, the way they come across, the way they look, the way they act, then focus group it and show it to a focus group. And obviously, the earlier you do that, the less expensive it is when you decide that I need to get a different horse. But you'll have that feeling. Now, obviously, if you know your expert and worked with them a lot, they're very good, then you're in good shape. But sometimes with a new expert, trust that gut feeling that you have. And if anybody looks at it and says, I got an issue here, go back and check. I've seen experts who were really good and then for the plaintiff and then got too cocky and started looking like they were carrying water and got into this. And then you're like, and it went from this expert's fantastic to this expert is so not neutral, regardless of the fact that he's paid. His attitudes, his way of sort of trying to gig the defense attorney at every turn, turned the jury off. And that case, unfortunately, had a bad outcome for the lawyers who were trying it, just simply because their expert was trying to do too much. So obviously he has a role and he has a lane, or she has a role, she has a lane. They have to stay in that and make sure that they stick with the system. It's your case, you're in charge. Make sure that you bring them to heel to ensure that they're going to do it the way that it needs to be done. And if not, like I said, it's time for you to go on and find yourself another expert. So let's talk now a little bit about some of the things that I see that go wrong at trial itself. Okay. And so, some of the things that I see that go wrong are that the systems failure isn't proven properly. Now, that shouldn't be a problem, but from time to time it occurs. So y'all all know when you do your opening, okay, and I teach advanced opening. So this is one of the things to really kind of hit on, is that opening is going to give you everything that you need That opening is going to have your statistic in it. That opening is going to have your rules in it. That opening is going to be talking about foreseeability and preventability, right? That's the name of the game here. So you're going to have those things together. You're going to have a timeline in your opening that's going to be showing what these defendants did wrong. You're going to have all of those things laid out very clearly and very visually. And what you're going to have to do is to make sure then that you've got the witnesses lined up to very clearly prove that systems failure. Okay. And so that's one of the things, is to keep your eye on the ball and to stay sharp when you're proving that systems failure, and keep it as simple as possible. Don't complicate it and don't fact it up. We always try to shoot for a 12-minute opening. Sometimes people can get it in 12. Sometimes you got to expand it because the focus groups say, I got to know this and I got to know that. But otherwise, if it's not essential to what it is for purposes of the opening, then leave it. You got a whole case to try. You're going to be able to get it in some other way, right? But remember, the average person has what, a 12-minute attention span, which means that y'all probably stopped listening to me about 30 minutes ago. But I'm just kidding. But that's one of the things, is to always try to keep that in mind as you're going through. That's the moment when you have their greatest attention, and so make sure that you use it. The next thing that I see, and this is going to fall in the category of why it is that you don't get the money that you want to get, okay? And that is going to be before and after witnesses, okay? And I know all of you who've gone through this know that before and after witnesses are worth their weight in gold, okay? I have been able in one case to get a 7-figure verdict with no before and after witnesses, because literally my client was a hermit for all intents and purposes. He and his dog, and that was it. Never talked to the neighbors, never interacted with anybody. His family was all gone, etc. But it was very uncomfortable to have him have to carry that much water on his own behalf without me being concerned that they were going to look at him like he was whining. So, but if you kind of, I've got this little sort of rocket progression set up. So if you've got one before and after witness, okay, versus multiple, and F means friends and family. Okay, so they're qualitatively different before and after witnesses, obviously, but they're better than nothing, right? So I tried a case recently. We got another 7-figure verdict on with 2 friends and families, with a mother-in-law and a fiance. And it was much better, obviously, than just having him alone. But if you can do the way that it's supposed to be done, the way that Don teaches it to be done, where you can go out and find folks who are not friends and family, people that know this person, people that have no stake in the game, and be able to put, as many on as can tell a different story, and as many on as the judge will let you, and that you sort of sprinkle them throughout the case, then you're going to see, just in terms of the damages numbers, that they come to life, and that you paint a very, very different story about what was taking place just with the addition of that. So remember, early on the intake, you're getting the before and after witnesses. You're getting all of their all of their phone contacts. You're running out and talking to these folks. You're getting video statements from them. Maybe you can use for mediation, maybe use later. That's all that front end work. But those folks, again, are going to be worth their weight in gold. And if you don't have them, it's, it kind of falls with a thud, as opposed to launches into space. Another thing that we kind of talk about is about the damages themselves. Okay. And everybody here who's taken the damages course knows what I'm about to show you. If you haven't taken the damages course yet, take it. I've taken the damages course 3 times. It's not just because I'm from Alabama and I might be slow. It's because each time I take it, there's something new. It's better than it was the last time that I took it. So, and right now it's just lights out in terms of learning certain things that are truism or major truths about damages that you have to know. Okay, you guys know this, but liability drives the verdict, right? And so as you're going through this process, you are always you're focusing on liability, you're echoing liability, you are pushing liability all the way through the case. All right, conduct drives the verdict. Okay, and this is the old awakens the reptile, but it's the edge here, is that you talk about danger. It's dangerous. Okay, that activity is dangerous, and you continue to show that as you go through the process. All right, no repentance. Again, early on, when you're asking those questions about accepting responsibility, about 3 things you could do different. Those various things and techniques that you're going to learn as you go through all of those things, and embracing the resistance, because that resistance will bring you a much bigger verdict a year or 2 down the road. You're looking for those things, making it safer. Obviously, that's something about damages, that safety component in there. And then the thing I think that we all inherently know, but it's important to remember, is the idea of emotion. Okay. And emotion drives everything. And so when you are going through and thinking about why it was that you didn't get the damages number that you were looking for, go back and check and see how you presented the case, and see, were these major truths being observed? Were you at all times going through and keeping this drumbeat in the background as you were putting on multiple before and after witnesses? Okay. As you were clearly explaining what all this meant in terms of all this medical mumbo jumbo, what it clearly meant in terms of the day-to-day life of an individual going forward and what they were facing. The simplicity of it allows for the emotional connection. When you start thinking about all of this stuff from the logical standpoint and from the technical science standpoint, it drags you away from the emotional part of it. And so make sure that you're keeping everything pushed toward that side, if you will, in terms of your damages model. All right. Let's see here. The next thing is going to be closing. Okay. And so closing isn't where you lose. Closing is where you lose money. Okay. And so when you get to closing, one of the things is, remember now, you have a pie for closing. Okay. So you don't have to recreate the wheel, right? You just have to put new tires on it for each kind of case so that you're ready to go. But you've got a very specific pie that you can follow, that's going to take you through each element to be able to do all of that. And one of the things that I see that causes me some hesitation when I talk to some of the younger lawyers I deal with is, this is a complete system. Okay. It has everything that you need in this system, and you have to have the self-discipline to follow the system. Sometimes people go, oh, well, let me go take part of another system, or not even a system. Let me go take a part of something else and stick it in here. Or let me use just part of this, and then I'm going to skip this and do this the old way and all of that. You create this Frankenstein system that usually turns on you, and you have a problem at the end. Okay. So, learning this and being willing to implement it, again, requires a lot of self-discipline for you to go through. But in closing, what your goal is, obviously, is, you've proven all of it. You told them you were going to prove it. You proved it. Now you're telling them that everything that you proved to them, but you're empowering them. And this pie that Don has created and put together for us has the step-by-step systematic way of creating that level of empowerment. Okay. And when I first, years ago, started doing this system, it didn't feel super comfortable. It felt a little awkward. Now, I get emotional when I'm talking about the importance of the justice system. I get emotional because I really, truly do understand and fully believe now, and have integrated that into my being, the understanding as to why it is so important that these people are there and what they're doing on behalf of everyone there. And once you really step into that and understand that, they feed off your sense of empowerment. When you believe it and you understand it, then it is amazing, the synergy that gets created and the level of importance that they truly do feel about what they're doing. So that's something that if you don't feel comfortable with it, it's just a matter of practice. But again, there's a system waiting on you that has everything that you need to take you through that. So at the end of every case, what I do is sort of go back and look and say, okay, what was it in terms of the major players, right? There's 3 players in all of this. There's me, okay? There's the judge, okay? And then there's the jury, right? And so the first thing that I look at for my own performance is I ask other people to watch me. And I know some people work for me, and that's hard, but I tell them, be honest, okay? How was I? Okay. And so was I off code? Right. So was I a teacher, and was I the nicest guy in the room? And that's a stretch for me at times to be the nicest guy in the room. But is that what I was while I was in front of those folks? Because that really is where you want to be. And it makes the case easier to try. It makes it more comfortable to try. And they look at you with a sense of trust, and you are able to tap into your authenticity if you can really just be yourself in a relaxed fashion, right? Part of that's being prepared, right? You can't be relaxed if you're not prepared. And if you've been running up until the deadline to get it ready, then that's going to be a problem. Am I tired, right? So have I been having to prepare things that otherwise should have been done a long time ago because something went wrong or because I failed to do the plan and to execute the plan? So am I really tired? And you guys know, anybody who's tried a trial that lasts more than 3 or 4 days, especially 3 or 4 weeks, you know how tired you get, and that if you haven't already packed all of your supplies ahead and put everything where you need it so that you can just grab it and go, how unbelievably stressful it can become, and then how that can affect your performance. So, and then am I confident? Did I appear confident the entire time that I was going through? So go back and judge your performance. And part of improving your performance is just all the practice that you're going to have as you're going through with these focus groups, as you're preparing and practicing your opening, practicing your closing, doing your hit list. Those are all opportunities for you to practice and to visualize. Okay, the next thing is the judge. So what was the point of view of the judge? How was the judge during the case? And so one of the issues is, did you surprise the judge? Did you sandbag the judge? Did you keep anything from the judge? So one of the other courses that I teach is black letter law. And for those of you who've taken black letter law, you know that one of the things we spend some time on is the point of view of the judge. What's it like to be a judge, to be put on the spot, to have to rule? What's it like to be a judge who isn't given all the information, isn't given it in a timely manner, is asked to do something under pressure in front of an audience? So did you put the judge in the best position that you could have put the judge in? So did you file a trial brief? Did you bring all of the issues to the judge's attention before you got there? Did you explore everything in your motions in limine? Did you put all of these things together? So obviously, the more organized that you are and the more heads up that you've given the court, typically, the better the result is in terms of rulings or just the general attitude of the judge about these things. So that's the last thing. And then the last thing is the jury. I mean, and obviously, this is the autopsy, right? So talk to them. But understand that what they say to you is not going to necessarily have anything to do with why they did it. I mean, that's not meaningful, but just listening to what they have to say. So one of the fun things I get to do for folks who have had a verdict, good or bad, is sometimes they'll ask me just to call up and do jury interviews. So I'll call up and I'll do a jury interview, and normally, I can find out in usually about 30 seconds exactly where it was on what we just talked about today. Everything went wrong. What they believed, what they thought, how they got confused, or that they didn't if it was a good result. But oftentimes when it's not a good result, what happened in terms of, was there a rat on board? Was there a complete misunderstanding of the timeline? Did they not, was the MOI, MOE off, and then they were skeptical? Because remember now, we can't be wrong once at all, because they're going to impute a motive to us that's not a good one. And so when that happens, what happens is they're going to turn around and think, well, those lawyers did it on purpose. And oftentimes, as y'all well know, we didn't do it on purpose. In fact, oftentimes we never thought about it. But that's what's going to happen to us. So, when we sit down and do the interviews and go through all of those things, that's what we're looking for, is to go back and find where in our compartmentalized system did we fail. And oftentimes we'll find we failed in more than one area, right? And so, and that's, as painful as it is, as I said earlier, it gives us the opportunity then to go back and fix it. And then the next time we go through, just like that string of Christmas lights you pull out and plug in, and you got to go check every bulb. The next time that you go through, you push it, you plug it in, and the thing lights up without a problem. But you know what to look for, you know what to do, you know how to deal with it. You've done your own systems failure. You have identified your own root cause, and then you have gone about fixing it. So that's something that for all of us who have that opportunity to do so, and again, it takes more time, that I would hope that each of you takes the chance to do it, or get somebody to help you do it. But don't ever lose a case or have a case where you don't get the outcome that you want and then just chuck it up to it was a bad jury and the judge was against me and well, I was tired. Whatever it is, don't make excuses for yourself. Go ahead and dig on in and find out, and then be more confident the next time you get up to bat. So those are just some of the thoughts that I wanted to share with everybody today with respect to, learning something from the results that you would rather forget.
Awesome. Thank you so much, Brent. That's,
Sure.
As I mentioned earlier, it really is something that we can't hear too often about. It really is, because it's so painful when it happens and it feels so out of the blue because you've worked so hard, especially those of us who subscribe to the EDGE philosophy. We worked our pants off and you're like, oh my gosh, this judge or this jury, they just didn't get it. They just didn't understand it. They gave me a bad rap. This judge just completely had it out for me. And I read a book once, most people have heard of it, I'm sure, by Ray Dalio. It's The 7 Habits of Highly Effective People or something like that. And I didn't even finish it. But my favorite thing that I learned from it, and I think about it all the time, is you are the only person that can change anything about your life or the outcomes in your life or anything. Even if somebody is mean to you, you're the one who gets to choose how you respond to that. If there's a bad outcome, you are the one who gets to harness that and learn from it and do something different again. So, it's not, yes, of course we have judges who are just awful. Yes, of course we have jurors who are super mean and just make you want to cry. But how you respond to that and what you do next is the most important thing. And I really appreciate you coming in here, Brent, and showing us all that it happens, first of all, and that there's a finite number of things that probably went wrong. And so let's look at those and see how we can do better.
Right. And not knowing creates a greater sense of fear in terms of, because heaven forbid it happens to you twice in a row. Right. Didn't go back and take that, because you can create your own blind spots, and if you allow those blind spots to just stay there without going and trying to figure out exactly what happened, then again you can't come in and be confident in the system, because if you took a loss, some people will run. So it's almost like people who trade stocks for a living, and that you have a specific system on how to do it. If you take 2 losses in a row and you don't figure out what's going on, a lot of people will abandon the system, and then they'll think, oh, well, this doesn't work, right? And I can tell you the system works. And the last thing I ever want anybody to do is to say, oh, there's something wrong with this or there's something wrong with that. No, there's not anything wrong with the system. You got to believe in the system, but when something goes the way you don't want it to go, then stop, go back. You can fix it. It's, like I said, as painful as it is to have to face your ego, you can go back and you can fix it. And then the next time when it works out really well, you feel that much more strong, that much more confident, that much more willing to continue to follow the system as you go forward. So.
Absolutely. Absolutely. Don't throw the baby out with the bathwater, as they say. Oftentimes I find when I've had results that are not what I wanted, it's absolutely because I either forgot part of the system, or I didn't quite do it right, or I had too much going on. And as you mentioned earlier on in your presentation, a corner got cut, and it won't work as well unless you really, really commit to doing it. Now, I know some people listening might say, well, hey, I'm halfway through discovery. I don't know if I can implement all this stuff. That's okay. When I did my very, very first EDGE case back in 2017, I think it was, I was 2 months from trial, and I implemented what I could, and it made all the difference. So there are some very, very fundamental philosophical things about the EDGE that can really change your case. And so I encourage anybody who's in that position to hop into a couple of colleges and, do what you can to learn the philosophy of it. Even if it's a couple months before you're going to stand up in front of that jury.
Absolutely. Yeah. I mean, just going to Welcome to the Revolution way back in the day, just the perception shift and the focus shift in terms of how to pursue things, the idea of systems failures, the focus on the defendant, getting away from your own client, those basic things enabled me to have great results in cases, like you said, that were already ongoing. So, and then certainly having a structured opening, just knowing how to do a certain structured opening or structured voir dire or close. I mean, it's again, absolutely a game changer, because you now have, one of the greatest trial lawyers ever has put together on paper for everybody a system that they can follow. And so if you only get one piece of it, you're still getting a big nugget of something that's very incredibly valuable to the way you're going to pursue your cases. So, grab it and run with it as best you can.
Yep, absolutely. And I think the best part of it is it's based on straight up black letter law. And you teach that course, Brent, but that's the thing. There is no magic. There is no manipulation. There is nothing shady. It's just that the defense has done so much shady stuff, and they have manipulated judges and juries and public perception, that it seems like when we come in and do these things that are based straight out of the mouths of the judges, the higher court justices, it seems kind of weird to everybody, because they, the insurance companies and defense black hats have spent so much time and money manipulating the public perception about it. But what we do is just bring the law as it is written and has been written for hundreds of years to the people. And that's it.
Yeah. And step one, though, for us is to go back and learn the law, because, we all read Paul's graph in law school and then forgot it.
And then just threw it right out.
And then after that, we stepped in and started practicing in front of judges who did not remember it, were not applying it, especially as tort reform has gone on and the decades have passed. Now, part of what the whole process is going back. When we talk about trial briefs, going back and reintroducing your judges to the fundamentals that they may have lost touch with. And so, once you do that, again, all of a sudden they see things very differently. And it's so much simpler. Practicing law is so much simpler when you return to the purpose of tort law, right? Mm-hmm. So when you talk about deterrence and preventability and very simple things like that, it seems like, oh, wow, this all makes so much more sense than when you listen to the defendants talk about
it. It does. And that's another thing, is it will take some time. So everybody have to be patient with the judges, because they've been as manipulated as we all were before we got back to the basics. And sometimes you'll have judges who are resisting, even if you show them quotes straight out of judges' mouths that they highly respect. But, that's going to be part of learning this system and making it work for you and your clients, and turning those L's into W's, is really being patient and showing the court that this is not, we're not manipulating anybody. We're just following the law.
Absolutely. So.
Awesome. Thank you so much, everybody, for joining us for this week's episodes of Fridays with Keenan's Cutting Edge. If you liked the episode, please click the thumbs up icon and subscribe. And also you can click the alerts bell so that you don't miss an episode. Next week, we have Mark Milholland with us, who is going to talk about the paralegal seminar. And this is a really neat opportunity to get your entire office on board with the EDGE philosophy. It's all well and good if you, as the lawyer, understand the philosophy behind it, and you know what you're doing in depositions, and you know what you're going to be presenting in trial. But if your office doesn't have a good understanding of how they're going to support you through discovery and whatnot, you can kind of you can fall a little bit flat there, and it can be a struggle. And as you heard today, discovery is one of the biggest ways we can get a W for our clients. So the support staff being able to help you there is very important. And this is a great way for your staff. I think it's called the paralegal seminar, but I believe legal assistants and whatnot can also attend. But we'll hear more about that from Mark next week. So I look forward to learning more about it with him next week with all of you. Have a wonderful weekend, and I will see you next time.